Consumer Counterpoint. This is the video cast that we're talking about consumer issues, particularly those that are being litigated in the class action space.
Yeah, and my name is Paul Yovanik. I'm a co-host, and today we're going to be talking about website tracking technologies, tools, a lot of litigation, particularly out in California that we've seen. And Christine, can you tell us a little bit about that?
Yeah, so for anyone that has a website, right, that's targeted towards consumers, likely your marketing teams are using tracking technologies. And what those tracking technologies are doing are they're collecting information about the visitors. What pages are they looking at? How many people are coming to your page? There's all different ways you can set up these tracking technologies. And it's for marketing purposes, right? To kind of better develop your marketing strategies.
Sure.
And when we talk about tracking technologies, we're talking about cookies, we're talking about pixels, we're talking about web beacons, pretty much anything that is looking at the ways in which the visitors are interacting with a website.
Sure. And so obviously, I mentioned California, and so we're seeing a lot of litigation over the last couple of years in California. Are there certain types of claims, certain statutes that are in play, maybe even at the federal level?
Yeah, so what we've seen over the last really 2 years, maybe 3 at this point, is plaintiffs are using wiretapping statutes. So statutes that were created decades ago, primarily for, to regulate people tapping phones, listening in on private conversations. And they're essentially using these claims, and there are state wiretapping statutes, and then there's also a federal wiretapping statute. And they're using these statutes to say that the tracking technologies are essentially listening in on what a consumer is saying to a website. So when I click on a pair of pants, a hat, a pair of shoes on a website, I am communicating to that retailer, I'm interested in this website or in this product. And so that communication then is being listened to by third parties, right? Those third parties that are, own these tracking technologies. And why we're seeing so much litigation in California is California's wiretap statute has an aiding and abetting clause.
Okay.
Right? So it's saying, you, the retailer, the website owner, whoever you are assisting these third parties, these owners of the pixels, of the web beacons, of the cookies, to listen in.
So essentially, I think we've talked about this in prior episodes too, of just like old statutes, new technology, and trying to just kind of make it work, which seems in some parts a stretch, and I just, obviously this has been going on for the last couple of years. So early on, how have the courts kind of been looking at some of these claims? Have they been, been suspicious of them?
Yeah, I think, to be fair, these claims are making it past the motion to dismiss stage, right? They fit enough within the statutory language to potentially apply to this type of technology. Some do, some don't, right? Some of the statutes are very specific as to telephone lines, that type of technology, and so some courts have made distinctions there. But some of the language is much broader than that, and arguably these internet communications fit within that language. And so, and courts are careful, to allow statutes to kind of grow with technology, right? We can't have legislature rewriting every time new technology comes out. That would never work.
Right.
But, this is an interesting twist to this type of technology, and it's been litigated pretty significantly for the last couple of years.
Yeah, and we obviously, as you mentioned, we see a lot of complaints passing the motion to dismiss. That's not the end all be all, of course.
Right.
With these cases, class certification, summary judgment, getting a second chance to really just show the court with through discovery why this is or is not a case or a claim or certifiable.
That's right.
And so obviously the plaintiff's bar kind of jumped on this opportunity. Like, what are we seeing from the plaintiff's bar? Like, how are they bringing these cases? How are they finding their clients? Like, how do you think they are finding the clients and bringing this information forward?
Yeah. So, I think, obviously you have a huge consumer pool of people who are accessing websites using this technology. And so there are experts out there, right, on tracking technologies. And I think there are some very viable privacy concerns, right? There's a lot of focus over the last couple of years. We talked about this on a couple of our other episodes, is like, people are concerned about their privacy and what is being shared and who it's being shared with, and are companies being transparent enough with the consumers, with their employees, with everyone, about what is actually happening with their information. And so this is kind of an offshoot of all of that. And so if you go on these websites, it's pretty easy to figure out what tracking technologies are there, right?
Sure.
You open up the developers' tools and you can kind of poke around in those and see what is firing, right? When you enter a website, what types of technologies, what types of cookies are are interacting with your browser. And so essentially that's what they're looking at, right? They're accessing that tool and they're saying, okay, these technologies are firing. What kind of disclosures does this website have to let the consumers know that this is happening?
Okay. Yeah, and so I mean, we get these, from in my experience at least too, we get a lot of demand letters, pre-suit demand letters. They provide information, and it kind of just seems like these plaintiffs' firms can be using the same person for multiple companies, and it's almost like less clients,
Sure.
more ability to go out and look for businesses to go after.
Yeah, we are seeing plaintiffs across the board, right? Similar plaintiffs. And I think this is a particular space where we're seeing what is known as tester plaintiffs, right? Individuals who are saying, I am a tester. I admit that I went to this website because I was looking for this type of technology. I'm also genuinely interested in this website, but I am doing this on behalf of consumers. And so you see then, right? And it's really, in most instances, it's a matter of visiting the website, right? Going to that URL, clicking around, and there's your cause of action.
So when we see these testers, they're issuing demands, or are they filing lawsuits, or are they both? Have we seen testers filing lawsuits? Or
Yeah, we have.
what are courts saying about that? Because it just almost seems like they're purposely looking for the violation, looking for the damage that they're creating, knowing that they're going to go find it.
Yeah, we've seen some case law come down on testers, right? It's a little bit different than kind of your normal tester who, in the discrimination or the ADA space, right? Because those people, are alleging discrimination is happening.
Sure.
Here, right, the tester is, as you said, creating essentially the violation, right? They're visiting the website knowing that those tracking pixels are there, and so they already understand what's happening, right?
Sure.
So the injury isn't necessarily there. So we've seen some standing opinions come down,
Sure.
Against testers, but again, I think most of these cases are making it past the motion to dismiss stage, surviving those standing arguments. And a lot of courts are finding that there is a potential privacy violation, which creates that standing, creates that injury that you need to make it, past Article 3.
Sure. And so, obviously now we, as you said, we're seeing these cases survive past motion to dismiss. So a lot of these kind of initial arguments, might be falling flat. Have we seen any success after a motion to dismiss, whether it's at class certification or summary judgment? Creative theories or defenses that was like, they're working, or they have worked.
Yeah, we've seen a good number of opinions come down at class cert, some granting class cert, some not, right? And it tends to be where the claims and the classes are super broad, that those class certifications are not surviving,
Sure.
right? Because when we're talking about visitors to a website, and this technology operates the same but different, right? So it operates consistently, right? It operates in the same way every time it's triggered, but the information that is being sent is going to be different depending on what it is that you're doing on the website. We also see some variation in terms of the type of website, right? So obviously there are certain websites that individuals are communicating in it that are maybe a little bit more sensitive, and then there's some websites where you're not sharing really private information, right? I used the example before of, looking at a hat, right? Is that really truly private information to me that I wouldn't want to be shared? Is that any different than me walking into a store and picking up a hat
Sure,
and someone
sure.
seeing me do that, right? If someone sees me do that, they know I'm interested in that hat potentially. Versus, maybe the healthcare space, maybe the financial space, where you might be sharing different types of information, more private information with that website.
Yeah, and it kind of just seems like also, as you said, the broader class definitions of just merely visiting a website.
Right.
It seems like, as you say, with these pixels, they are firing certain actions, certain web pages within that website, and so obviously, if it's just everyone visiting the website,
Right.
that alone, I can certainly see where there would be some certification issues.
That's right. I mean, and I think what's really important here, and what summary judgments we'll start looking at, and we haven't seen many summary judgment opinions yet, but is consent is a defense here, right? And so whether or not you have disclosed this type of technology or the uses of this technology for marketing purposes to the consumers that are visiting your website, and how you have disclosed that is really going to come into play here.
Right.
Because if a company can prove that they made that disclosure, had that consent, then the claim goes away, right?
Yeah.
Then they succeed. So we're really, when we're talking to companies about mitigation, we're really saying, well, what kind of disclosures do you have on your website? Because as we've talked about in other privacy related chats, transparency is everything,
Yeah.
right? The key and the idea and all this privacy focuses on being transparent with consumers about what is happening.
Right, and that kind of was the last thing I wanted to touch on, was really mitigation efforts. When we're working with clients, when we're looking at these websites, are there kind of some high level, what do we want to be mindful of? What do our
Right.
what do our viewers want to be mindful of
Yeah.
as well?
So I think, right, the number one thing is knowing what technology you're using.
Sure.
Right? I think over the years, there's been so much technology that has become available, and marketing groups rightfully have jumped on the opportunity to use that,
Right.
that all of a sudden there's a buildup of technology on a particular website that may or may not even being used. So running an audit on your website and seeing what types of technology do we have here that may be sending any information to third parties, and auditing whether or not you truly need all of that.
Fantastic.
Right?
Yeah.
That's a really important first step when we're looking at these.
Yeah, and we
these
always
websites.
talk about know what your technology is doing, whether it's biometric privacy, whatever.
That's right.
Everything, like, know what it's doing, know what it's not doing, and be familiar with that.
Right. And then in terms of consent and transparency, right, everyone can kind of generally expect a cookie banner to pop up. We strongly encourage companies to use cookie banners with that disclosure, right? So it pops up when someone visits a website and makes a disclosure of, we use cookies on this website, we use pixels on this website, we use them for marketing purposes, we use them for functionality purposes, we use them to enhance your experience. There's all sorts of language you can use, right? And making sure that a user can opt out of the use of those cookies, those use of marketing pixels, if they want to, right? That's typically what we'll see and what we'll recommend in a cookie banner. And that, presumably will give you, right? We don't have rulings on what is the exact consent needed yet, but that presumably will give you a good mitigation and a good argument that you have that consent that you need.
Right. Yeah, it just, again, we talk about, transparency, and then it also just seems like the other part of that is, if someone says and rejects these cookies, making sure that it actually is rejecting the collection. Right. Otherwise, what's the point?
Right. I mean, this is all about computer code,
right,
and how it's firing and when it's firing, and well beyond my capabilities in terms of, writing code for a website. But you do want to make sure that your vendors, if you have a vendor that's operating that cookie banner, or your internal people, are testing to make sure, if someone rejects all, as you just said, that those marketing pixels are not firing. And that's part of that is making sure the code is there correctly, and part of that is making sure that the cookies or the pixels are categorized correctly. So you see, when you go to a website, oftentimes you'll see cookie categorization, right? These are marketing cookies that we use. These are strictly necessary cookies that we use. These are functional cookies that we use. And so you want to make sure that those are categorized correctly.
Because you see that on the websites too. It's
That's
like
right.
accept all, accept only as necessary, and like
That's
even
right.
sometimes I'm like, well, what does that even, what does that mean?
Right. And so these types of pixels where you're sending information or data is being collected by third parties for marketing purposes should be categorized as marketing pixels, and someone should be able to turn those off, because if you turn those off, it's not going to affect the functionality of your website, right? And then make sure that if those are turned off, that those aren't firing,
Sure.
right? That's kind of low-hanging fruit for these types of cases, and hard to defend against, right? If a consumer makes a selection, you want to make sure that selection is
I
honored.
said I did not want this,
Right.
and you did it anyways. It's a really hard,
Right.
it's an uphill battle.
Yeah, I mean, and then just some other things that we can think about is our privacy policy up to date? Do we have a terms of use on our website? Does that terms of use have an arbitration provision? Now, there's a lot of reasons to include an arbitration provision or not to include an arbitration provision, but if you have an arbitration provision, you want it to be enforceable.
Yeah.
So
Yeah.
including that disclosure on maybe the cookie banner that says, by using our website, you're agreeing to our terms of the use, you're agreeing to our privacy policy, again, creates that transparency, creates those disclosures for the consumer to say, we've told you everything you need to know, and you are choosing to still interact with our website.
Right, and that seems to be really where the courts always try to focus on, like, how is the consumer being, informed, and, are their wishes being,
Right.
granted, of what is going to be captured and what is not going to be captured.
Right.
So, I mean, this has been great.
Yeah, I mean, and given the risks, right, because under a lot of these statutes, we're talking about thousands of dollars per violation. Under the California statute,
Right.
it's $5,000 per violation. So, it's important for companies to look at, like, that mitigation opportunity and whether or not, how conservative do they really want to be. Now, it's important to note, and we'll probably cover this on another video cast, but there is legislation that is potentially
Right.
going to kind of curtail some of this litigation. But for now, it's not there.
Right.
Right. And so for now, you want to really be auditing your websites and looking at how you can mitigate against this risk, because when you're talking about $5,000 per visitor to your website or per interaction with your website, that's a really, really big number
Yeah.
for anyone.
Especially for those busy websites, for sure.
That's right. That's right. So we'll be back, I'm sure, with lots more
Right.
on tracking technologies, the updates on the legislation, case law as it comes down. But, this is kind of where we're focused now in terms of mitigation and where these cases are.
Awesome. Well, thank you, Christine. I really appreciate it.
Yeah.